This is a California legislative explainer on key end of session process items. Now, this is not an exhaustive list, of course, but I hope to cover some of the most frequently asked questions regarding process items at the end of the California legislative session. First one is 72-hour in print rule. A bill cannot be passed or become a statute unless that bill and any amendments have been in print and published on the internet for at least 72 hours before the vote is taken, unless the governor has submitted a statement that the bill is needed to address a narrowly defined state of emergency. No bill may be passed unless a majority of members of each house votes in favor of the bill. Consent calendars. There are different rules between the Senate and Assembly regarding what is a measure on the consent calendar on their respective floors. For example, under Senate Rule 28.3A, if a Senate bill or an Assembly bill is amended in the Senate to create a new bill or to rewrite the bill, then a standing committee may not place that bill on its consent calendar. Note that there's also things called the special consent calendar on the Senate floor, as well as batching on the Assembly floor. Inactive files, bills taken off the Senate inactive file are returned to the second reading file, while in the Assembly, bills that were previously on third reading that are moved to inactive are subject to a one calendar day notice when removed from the inactive file and then are returned to the third reading file. Session going past midnight on the final day. This notion of stopping the clock is a term used to describe the process of continuing legislative business after the passage of a deadline imposed by legislative rule. However, there is no such provision to stop the clock in the legislature. During the second year of the legislative session, the state constitution specifies that no bill may be passed after September 1, with 5 enumerated exceptions, which makes August 31st at midnight the de facto deadline in the even numbered year. Policy committee hearings during the last 2 weeks of session. With a rule waiver, committees can meet during this otherwise called blackout time. But under Senate Rule 29.10 and Assembly Rule 77.2, dealing with bills that have been substantially amended in the other house and that are referred back for a policy committee hearing, those committees are not subject to the prohibition on meeting during the last 2 weeks of session. Double jointing versus contingent enactment amendments. There's a clear difference between these two. Contingent enactment means that there's a section in a bill indicating that it will become operative only upon the enactment of another measure. Double jointing amendments are amendments to a bill providing that the amended bill does not override the provisions of another bill where both bills propose to amend the same section of law. And the final thing is, where can bills be located beyond the second and third reading files? Unfinished business, inactive, and worse. Unfinished business file in both the Assembly and Senate daily files, there's a portion titled Unfinished Business, which comes between the second reading and the third reading. It contains bills that have been returned to their house of origin from the other or the second house and await a concurrence vote due to amendments that were made to the bill by the other house. This section of the daily file also contains bills that were vetoed by the governor. They remain on the daily file for 60 calendar days after the gubernatorial veto, with some exceptions for recess time. The inactive file. The other section of the daily file to be aware of is for bills that made it to the floor of either the Assembly or Senate, but for whatever reason, the author of the bill chooses not to proceed with the measure. Bills that have failed passage can be moved to the inactive file upon request of the bill's author. If an author has moved a bill to the inactive file, then he or she can remove it from the inactive file at a later date with public notice. Finally is a WORF, W-O-R-F. According to the rules, bills that are not listed on the daily file can only be taken up with either unanimous consent or by suspending the rules, the order of the day. A bill that's not listed on the daily file, but which is taken up nonetheless under that suspension of rules is referred to as a WARF. The process of taking up a wharf is to take the measure up without reference to file. In order to do so, a vote of majority on the floor, so 41 votes in the Assembly or 21 votes in the Senate, is required to take a bill up without reference to file or a wharf.